215, 1 year statute of limitations. Statute of limitations. This is 215. 1. Action against sheriff, constable, coroner, except for non-payment of money from execution, because that's a 3-year statute of limitation. 2. Escape of prisoner arrested on a civil mandate. 3. Assault, battery, malicious prosecution, libel, slander, violation of right to privacy, false words causing special damages. 4. Penalty given to informer, enforced penalty or forfeiture. However, if not done by private person within 1 year, state can do it within 3 years. 5. Collect an arbitration award. 6. Overcharge, enforced penalty on overcharge of interest. 7. Action by tenant, 223-B sub 3 of real property law. 8. 1 year after termination or conviction, except for sex crimes in first degree. 5 years after termination of criminal action. So let me do those again. This is the 1 year statute of limitations in CPLR 215. 1. Action against sheriff except for non-payment. 2. Escape of prisoner arrested on civil mandate. 3. Assault, battery, malicious prosecution, libel, slander, violation of right to privacy, false words causing special damages. 4. Penalty given to informer, enforced penalty, forfeiture. 5. Arbitration award. 6. Overcharge of interest. 7. Action by tenant. 8. 1 year after termination of criminal action, you could sue the person. Oh, I was definitely up to 215. My little doggy's here. He's so cute. He wanted some love. Okay, so 216 is saying that you cannot, if you get a notice that there's already an action pending for the money that you wanted to sue for, you get a notice, even if the court didn't have jurisdiction over you, you cannot go and sue that New York defendant for that money because it's been a year past and you had a year to intervene or start a new action for that same money if you were the claimant. And that is going to be explained further when I actually get into the stuff about the claimant and the 1 year thing. The action is pending for an order allowing him to notify this other claimant that this lawsuit is pending and that it's the same money. Oh, baby, you have water? All right, so this is 216 sub 2. If any person shall make claim for the recovery of any sum of money due and payable under an account or contract, and an action has theretofore been or shall thereafter be commenced by another person to recover the sum exceeding $50, the defendant in such action may, within 20 days from service upon him of the complaint or from the receipt of him of the claim, whichever occurs last, he can make a motion to the court where the action is pending for an order permitting defendant to give notice to this other claimant that the action is pending. The court shall grant the motion where it appears that a person not a party to the action has made claim against defendant for the same money exceeding $50 in amount or a part thereof, and that the action was brought without collusion between the defendant and the plaintiff, and that the claimant cannot, with due diligence, be served with process in such a manner to obtain jurisdiction over his person. The order shall provide that notice be given to the claimant by sending a copy of the summons and complaint by registered mail, or if there's no registered mail wherever he is, then by regular mail. On such terms as conditions as order may direct. Proof that the notice has been mailed shall be filed within 10 days from the date of the order. Otherwise, the order becomes inoperative. Upon such filing, notice shall be deemed to have been given on the 10th day after the date of such order. Well, that doesn't make any sense, because if you have to mail it within 10 days, he's not going to get it within 10 days. Anyway, upon proof of affidavit by otherwise, the satisfaction of the court that the conditions have been satisfied and that there is no collusion between the claimant and defendant, the court shall make an order staying further prosecution of the action for a period not to exceed 1 year. The stay shall be lifted upon proof by either party that the claimant has brought a new action in any court of the state or has intervened in the action that's already pending. At the time of granting such order or any time thereafter, the court, upon the motion of any party, shall, as a condition of the order, impose upon the defendant such terms as justice may require as to the furnishing of an undertaking in an amount to be fixed by the court. The stay shall be vacated, the undertaking discharged upon proof by any party, the claimant, that the claimant has intervened in the action or sued the defendant in another court of the state. A motion for any relief shall be made on notice to other parties in the action. So the defendant makes his motion, has to be by notice of motion. It can't be by order to show cause. Whenever claims are made by two or more persons, each claiming to be to the exclusion of the other, the duly authorized deputy or agent to demand, receive, collect, sue for, or recover the same money due and payable under or on account of a contract exceeding $50, and on behalf of the same person, each person making such a claim shall be deemed an adverse claimant. Notwithstanding that an action has been commenced in the name of or on behalf of the purgant, oh my God, this is great. It says, notwithstanding that an action has been commenced in the name of or on behalf of the person for whom he claims to be the authorized agent, any such adverse claimant may be notified of the pendency of an action as provided in this subdivision and may intervene in the action and be designated as claiming to be or as the alleged deputy officer or agent. What? Oh my goodness. Okay. I'm going to have to break that down and get back to it. 6. Whenever an action has been commenced for the recovery of any sum of money exceeding $50 and payable under an account or on a contract, and the records of the defendant show that a person other than the plaintiff has the right, exclusive of other deputies or agents of the plaintiff, to demand, sue for, and recover the same money, either in his own name or on his own behalf, or as the authorized agent of the plaintiff, and the defendant has received no notice of transfer, revocation, or other change in right or authority acceptable to it, the person so appearing on the records shall be deemed to have made an adverse claim to the sum of money and may be treated as an adverse claimant. Action to recover property. This basically says the same thing. They're treated as an adverse claimant in which the action is pending, has no jurisdiction over the adverse claimant, to direct the issuance of process, or if the same be issued, it would be without effect, notwithstanding the action seeks to have declared, enforced, regulated, defined, or limited rights upon specific personal property within the state. The defendant within the action may, within 20 days after date of service, or 20 days of the receipt of the adverse claim, whichever occurs last, he can make a motion to the court for leave to give notice in the same way as the other section. And then upon granting of such order, the provisions of sub A shall apply insofar as they are compatible with the subject matter of the action. 217. Unless a shorter time is prescribed, a proceeding against the body or officer must be commenced within 4 months after the determination to be reviewed becomes final and binding upon the petitioner or the person he represents in law or in fact, or after the respondent's refusal upon the demand to perform its duty, or with leave of court where the petitioner or the person whom he represents was under a disability within 2 years after such time. So that is an exception that I did not memorize when I studied for the test the first time. It's a 4-month statute of limitations, but when the person is under a disability, 2 years. Specified in 208, which is infancy or insanity. There's 2 years. Okay, an action against your union for breach of its duty, 4 months. Action against an employer pursuant to the labor law or civil service law shall be commenced within 4 months of the date the employee knew or should have known the breach had occurred, or within 4 months the employee actually suffering harm, whichever occurs last. All right, this is a weird one. I don't know when. Oh, this is from 2013, so I didn't know. I didn't have to know it before. This is 217-A. Actions to be commenced within 1 year and 90 days. Notwithstanding any provision of law or the contract, and irrespective of whether the relevant statute is expressly amended by Uniform Notice of Claim Act, every action for damages for injuries to real or personal property or destruction thereof, or personal injury or wrongful death against any political subdivision, any public authority, or any public benefit corporation that is entitled to receive a notice of claim as a condition precedent to commencement of an action shall not be commenced unless a notice of claim shall have been served on such governmental entity within the time limit established by 50-E of the General Municipal Law, and such action must be commenced in compliance with all the requirements of such law, and 50-I of the General Municipal Law, except in an action for wrongful death against such an entity, an action for damages to injuries to real or personal property or destruction thereof, or personal injuries alleged to have been sustained shall not be commenced more than 1 year and 90 days after the cause of action, therefore shall have accrued, or within the time period prescribed by 2 in the morning right now, I think. Any special provision of law, whichever is longer. Nothing herein is intended to amend the Court of Claims Act or any provision thereof. So basically, if you're going to sue a governmental entity and you have to serve a notice of claim on them, you have 1 year and 90 days. And it doesn't matter whether the relevant statute is expressly amended by the Uniform Notice of Claim Act. You have a year and 90 days. 218 says actions barred at effective date. Nothing in this article shall authorize any action to be commenced which is barred when this article becomes effective, except insofar as the right to commence the action may be revived by an acknowledgement of payment. B. Cause of action accrued and not barred at effective date, where a cause of action accrued before and is not barred when this article becomes effective. The time which an action must be commenced shall be the time which would have been applicable apart from the provisions of this article, or the time which would have been applicable if the provisions of this article had been in effect when the cause of action accrued, whichever is longer. And that is a wrap of Article 2.